Welcome to Talk Lex, a podcast dedicated to common sense discussion of legal issues facing everyday people. Brought to you by DeRazio Peterson. For more information, visit DeRazioPeterson.com. Welcome to another edition of Talk Lex. I'm Scott Peterson. Yes, it has been a while. There's no real excuse. Life has gotten in the way. We're back on what I think is going to be a regularly scheduled program here. Giovanna is with me today. We're going to talk about some news stories, legal stories, things in the news, and bring everybody up to speed on our kind of thoughts on some of the legal issues in the news of late. Anything to add before we get into this? No, shaking her head. That means I'll take that as a no. All right, first up, Alex Jones. So this case has been all over the news for a long time. If you don't know who Alex Jones is, I don't know what else to say, but he's a conspiracy theorist, provocateur, had a website or has a website known as InfoWars, where he peddles all kinds of nonsense, and became notorious following Sandy Hook when he went crazy with his conspiracy theories, claiming all sorts of things, such as that the entire thing was made up and that the parents of the victims of the Sandy Hook shooting were paid actors. Needless to say, that didn't work out well for him. You want to give us a little bit of background on what happened here?
Well, after he made a lot of these statements on his radio show, they reached millions and millions of people and sort of unleashed this troll storm on the victims of this shooting and their families. One of the disturbing things that I read is that the daughter of the principal who was killed in the shooting started receiving rape threats at her home. So whether he intended it or not, and he was doing this just for entertainment value and to grow his audience, it had some very real consequences for the people involved. So he has been the subject of a few different lawsuits, and his broadcasting company in Texas and Connecticut. The Texas was the first one to be in the news when there were some pretty big verdict against him in both damages and punitive, but the Connecticut one is the big one that's been in the news.
Yeah, so we talked about the Texas case a few episodes ago, and we discussed the fact that he didn't do himself any favors. He failed to comply with basic discovery demands, which is all part of litigation, and the judge found him in default, which meant that the jury didn't have to reach a conclusion on liability. They only had to determine how much he had to pay. The interesting part about the Connecticut case is that one of the things the jury had to consider was the Connecticut Unfair Practices Act and whether he had violated it. And they determined that he did. Broadcast internet retail businesses drove profit with broadcasts that intentionally and falsely vilified the victims and the families. So what the jury found was that his actions did violate the Connecticut Fair Practices Act, which then subjected him to punitive damages. So let's step back a second. This trial that took place in Connecticut has been handled over two phases. The first phase was directed towards what are known as the compensatory damages. And the second phase is going to be addressing what are known as punitive damages. Do you want to just break down the difference between compensatory and punitive damages in a lawsuit?
Yeah, so your compensatory damages is sort of a broad term for, damages that are going to literally compensate you for your losses. So in this type of case, the compensatory damages are primarily emotional distress and that type of thing directed to the families. It could be, financial loss, lost wages, those types of things can all sometimes be under that big umbrella. Punitive damages are not always available, but when they are, it's literally punitive to punish the person who did this and also to deter others from doing anything like that again.
So the jury awarded $965 million in compensatory damages. Needless to say, that's a big number, and it's clearly meant to send a message to Alex Jones and other would-be Alex Joneses that this kind of behavior is not acceptable in society, right? Obviously, he can't pay $965 million. That discussion will be left for another day. But when it comes to the punitive element, the plaintiff's attorneys have calculated that they may be entitled to somewhere north of $2 trillion based upon the reach of Alex Jones's audience. One of the articles I read indicated that they've calculated that his theories reached 500 plus million people. And, we were talking offline before we got on here, there are real world consequences to this. People showing up at houses, being threatened. So it's not to say that, he's just saying these things innocuously. People actually believed what he said and they took it to the next level. Any other comments on the Alex Jones case? It's going to be interesting to see how this plays out.
Well, I think we should probably talk a little bit about the fact that part of this case was a defamation case. And I think that's where the free speech issues come up. Because there are, I think, probably a good portion of people out there who think that no matter how vile something is that you say, you're still entitled to say it. And that's true sometimes. But in this particular situation, I don't think it was, because he called other people liars. He said that these families were lying, that they were actors in a hoax, and that they were doing this for some sort of gain. That is defamation, or at least the law supports that being defamation. In New York, there's Court of Appeals precedent that calling someone a liar is defamation. That doesn't mean that you can't defend yourself. Sometimes this comes up in the sexual assault context where, an accuser comes forward with accusations, and then the person who those accusations are directed towards, are they allowed to defend themselves? Absolutely. Are they allowed to deny the allegations? Yes. When could there be a problem? When they call you a liar, when they say you're lying to get money. Those things can rise to the level of defamation. And I think that's what's happened here. And it's kind of important to sort of keep that in mind when you're thinking about, is something free speech or not free speech? Defamation is not protected speech. And when you go to that next level where you're making a statement of fact about someone, then you start to not have the free speech protection that you might like to think you have.
Yeah, and this is a good segue into the Kanye West stories that have been out there, because I think there's a lot of comparison between the comments that Alex Jones made and the repercussions that Alex Jones is now facing, and the comments that Kanye West has recently made as it relates to the George Floyd case and the repercussions that it may bring for him. Kanye West, for those who don't know, is a media fashion mogul who has had multiple instances of bizarre behavior over the years, and has continued to kind of go downhill in recent weeks in particular. So a couple of weeks ago, he was on a podcast and was discussing a documentary that he had watched that had been made by Candace Owens, who is a media personality. Is that right? I don't know her.
I think so. She's also like a conservative provocateur sort of person. Okay.
So he's watching this documentary that Candace Owens made, and he gets on the podcast and he essentially says, I'll read exactly what he says. He said, "I watched the George Floyd documentary that Candace Owens put out. They hit him with fentanyl. If you look, the guy's knee wasn't even on his neck like that." That's a direct quote taken from the interview. So in response to his comments, the family of George Floyd sued him for $250 million for defamation and intentional infliction of emotional distress. Now, I am admittedly a fan of Kanye West, a lot of Kanye West music, not all of it, but it's actually very sad what's happened with him in the public and his kind of meltdown over the years. But that's, I guess, neither here nor there. The real question is he potentially liable for defamation? And if not, what about for intentional infliction of emotional distress?
So on the defamation piece of it, I would say, probably not. At least in New York, you can't defame a dead person. I think that's going to be an issue. I don't know that he actually said anything. I don't really understand what he meant about hitting him with fentanyl. I'm just not understanding what that terminology means. So I don't know that he was saying anything bad about George Floyd himself. But I think, at the very least in New York, you can't defame someone who is deceased. So I don't know what I think about the defamation part of it being particularly successful. The intentional infliction of emotional distress by his family, I think does raise free speech issues. People may remember that back in, this was 2010, there was a pretty famous Supreme Court case involving the Westboro Baptist Church. So I don't know that they're in the news as much as they were anymore, but at the time they were in the news a lot because they would protest at military funerals. And their reason for doing so was to draw attention to their, sense that the United States is in the toilet morally because of homosexuality. So they would go to these innocent families who are mourning their service member loved ones who died in the line of duty, and they would go and have a protest at these people's funerals. And I think everyone was pretty much on the same page that this is not okay. However, what I think many people may have been surprised to know is that when the Supreme Court took this case, almost unanimously, it was 8-1 with, all the liberals and all the conservatives pretty much siding together. They said that speech was protected. So the family who sued because this protest was going on during their son's funeral, and they sued for what in New York we would call intentional infliction of emotional distress, and they won over $10 million at the trial level. Ultimately, the Supreme Court said that the speech was protected, which means that you would not be able to sue someone, because in that sense, the First Amendment protects you from government intrusion on your speech. So in a lawsuit context, it's the court that is acting as the government. So in certain types of lawsuits like this, you can raise the First Amendment as a defense, and that's what happened here, and they were successful. Primarily because they said that this speech might not have, been appropriate in any way. It was still speaking on a broad kind of matter of public concern, regardless of whether the public agrees with you or not, and was not necessarily directed towards this particular family as some kind of private vendetta. And I think kind of leaving room that, there would be circumstances where speech could be private and very specifically directed to one person where you would be able to sue them. And just as a footnote, there's plenty of times where you can get in trouble for your speech. We practice an employment discrimination. You can't harass people. You can't say disgusting sexual and racist things to people at work. That would be a situation where your speech would not be protected. So I think that will probably be a legal issue in that part of the lawsuit against Kanye, depending on how far along it gets. Maybe his speech, you could make the argument, was more personally directed to that family as opposed to something more broad. But the first thing the Westboro Baptist Church was the first thing that popped into my mind when I heard that they were going to sue him under that kind of theory.
There's a couple of interesting things about this situation. The first of which is that 2 years ago, he donated $2 million to the families of George Floyd, Breonna Taylor, and Ahmaud Arbery. And he apparently started a college savings fund for George Floyd's daughter. So, the guy is, I think, having some some issues, obviously, which, we haven't even discussed his anti-Semitic comments and all the cancellation he's had from his sponsors and all those other things. But I also think there's a distinction between the comments that he's making and the comments that Alex Jones made. I think, as you said, Jones was specifically targeting the families of the Sandy Hook victims, calling them liars, expressing these things as his own, feelings, statements, truth, reality, whatever you want to call it. I think Kanye West's situation is a little bit different. I think, obviously what he's saying is reckless, probably pretty egregious and more than likely wrong. But he's also seems to be reflecting his opinions of a documentary that he saw that he didn't make. So I think it's going to be a challenge to prove that he intentionally made these comments in some way to inflict emotional distress on the family of George Floyd. That seems like a high burden. New York has a really high burden for intentional infliction of emotional distress cases. We see these cases from time to time with potential clients, and I don't believe we've ever actually taken one on because the burden is so high.
Yeah, I think we had one case where one of our causes of action was intentional infliction of emotional distress, and we actually did make it over a motion to dismiss, which is sort of the first type of motion a defendant can make to dismiss a case. The case ended up settling, so we never, got to the point where they would have a second bite at the apple. But I'm pretty sure that this is an accurate statement that in New York State, there are no intentional infliction of emotional distress cases that made it to a trial. I think it may not be an exaggeration that you won't be able to find one. That's not to say that those cases don't exist and they don't settle, but in terms of making it over some of the hurdles in the case where a defendant is allowed to dismiss it, I would say probably 99.9% of the time, if not 100% of the time, they get dismissed.
My prediction on this one is that when Kanye comes out of whatever situation he's currently in and starts to think more logically, there will be either an apology combined with a settlement or just a quiet settlement that makes this go away. I think it's very unlikely that they defend this thing to the end. I also think it's unlikely that the case ever goes to trial. I would predict that the case would be settled and you won't hear much more about it. Could be wrong, but that's I think probably how this will go. Moving on, there was a pretty brutal attack of the Speaker of the House, Nancy Pelosi's husband, last week. We're not going to get too much into the specifics of the attack other than to say it's obviously political violence in any way is a problem. But what I think is interesting from a legal perspective is that it's come out that apparently surveillance footage caught the attack or the assailant, and there was no response, or there was a delayed response, which in our world equals negligence generally, right? When somebody has a duty to do something and they don't do it, that typically rises to the level of negligence. But it brings up kind of an interesting scenario in the context of police and fire and EMS and responsiveness and requirements. So what do you think about what happened there, and how does that translate into like real world examples of negligence in these kind of situations?
Yeah, so in the law enforcement context, that kind of general negligence theory doesn't really apply. The law protects, and in many ways rightly so, the police and fire departments and other law enforcement entities from, being sued for every move that they make because of the nature of, what they're doing. We talked about this when we talked about gun violence and the Uvalde shooting, because as we all know, eventually, as all the information came out, law enforcement just completely dropped the ball in that situation, using not very probably the easiest language to use to describe what happened there. But ultimately, most people looking at it from a legal perspective said there probably wasn't going to be legal recourse because there's no sort of constitutional right to have your life saved by the police. In New York State, sort of a caveat to that is if you're in what we call a special relationship with the police, you may be able to sue them for negligence, or I'm saying police, but I mean any sort of law enforcement. But what that requires is that they basically give you instruction that you rely on to your detriment. So if you're on a 911 call and you say somebody's in the house and 911 says don't move, and you don't move, and that person kills you, maybe you have something against the law enforcement agency in that situation. But in general, you don't really. So I think in this particular situation, I don't know that there would be some kind of negligence theory necessarily against the Capitol Police for, it sounds like what they were not adequately monitoring the surveillance cameras. I have a hard time wrapping my mind around how that's possible, because she's third in line. I mean, it's a little scary whether you like Nancy Pelosi or not. I mean, if it's your guy or woman in that position, I think it's a little scary to think that they don't have eyes on their home, and that somebody could just walk in and basically almost murder your spouse and sort of lie in wait intending to kidnap you. I find that to be extremely disturbing. As a side note, I think all that hoax kind of talk is already happening about that. So we'll see if there's going to be somebody else who's going to be Alex Jones 2.0 for talking about this being a big hoax.
Yeah, I'm not sure anybody learned the lesson yet from Alex Jones, but we'll have to see. All right, let's move on to a couple of topics that we talked about in our newsletter this week. If you haven't read our newsletter and you're not subscribed, you are missing out big time. Go to our website and sign up for our newsletter. You won't regret it. One of the things we talked about this week was Giovanna's column in the Saratoga Today, which if you're not reading that and reading our column, you're also missing out. So I'm not really sure what you're up to. But the column is about political activity and voting at work. The midterms are coming up. I won't be sad to see the end of political flyers and political ads on television. But it begs the question of, what's protected at work, if anything. A big part of our practice is employment law. And, people want to know, what can and can't I do? Can I be fired from my political affiliation? Can I be fired because I like Trump, because I hate Trump, because I like Biden, because I hate him? What is the answer to all of this?
Well, the answer, as everyone knows, to all legal questions is it depends. So in New York State, we have a little bit of protection for political activity. In general, your political beliefs are not protected under federal or state law. Yes, the First Amendment can come into play for public employees when they're speaking on matters of public concern. I don't think that's necessarily going to extend to someone's personal political beliefs. But public employees can sometimes have those free speech arguments to make. In general, you don't have much protection for your political beliefs, but in New York, we do have a section of the labor law that protects certain political activity, but it's pretty limited. So all it includes is running for public office, campaigning for a candidate for public office, and participating in a fundraising activity for the benefit of a candidate, political party, or political advocacy group. There's not a ton of case law on this. There was actually a pretty recent Second Circuit case on this where someone was given the choice to either run for office or, the choice between running for office and losing their job. Their case had been dismissed, but the Second Circuit is the federal appeals court that covers New York. They actually reinstated the case. They said giving somebody that type of what they called an impermissible choice between running for office and your employment would violate the part of the statute directed to running for public office. Interestingly, the court sort of noted that actually holding the elected office was not necessarily protected. I think the lower courts thought that because of that, this was sort of a no harm, no foul type of situation. But the court did think that that distinction was relevant, which if you think it through, it is, because this individual actually ended up losing his election. So he never got to the point of holding the public office, but he did lose his job. So that's really all we have. And we've definitely seen in the news here and there people losing their jobs for expressing their political beliefs in some way, whether it's, the woman who gave President Trump's motorcade the middle finger. She was all over the news. She got fired. Or, we see people participating in, protests, or Colin Kaepernick taking a knee, is some sort of political speech. I would describe it as well. So we often see employment consequences for expressing your opinions. And I think most of the time, people are probably out of luck unless you are kind of falling in another specific sort of protection under the law. And, in New York, we do have some voting rights as well, where you can take time off to vote if you don't have time outside of work hours. So that's just something to keep in mind kind of going into Election Day.
All right. So the most important takeaway here is to vote. And like everything else, as with social media and pretty much everything, use your judgment as to how much you want to discuss these things, because there are potential consequences. Thanks for listening. If you're enjoying the show, please subscribe, leave us a good review, follow us on Instagram, do all the things. And if you have any questions, message us on Instagram, and we will be back next week with some more discussion. Thanks again.